then I will have to rely on the good faith of the people who are online that, and that will put the pressure on Ms. Moore to contact people as they're called as witnesses. If,
President
you know who
Bach,
yes,
I was not provided with any phone numbers for contact for any of the witnesses. I would have no way of contacting them when to step into the hearing to speak.
you're right. That's what makes it awkward when we have a hybrid meeting. In the old days, once in a while, we had a sequestration of witnesses, and the people could just sit out in the hallway. Have Attorney Headley, have you had any communication with Ms. Moore as to the order of the witnesses you intend to call?
I intend to call Assistant Chief Sarno first, and I have his contact information that I'm able to
Well,
communicate.
then he's not a problem.
Correct.
So, do you know who you're going to call second?
Deputy City Attorney Mary Shannon.
All right.
And I will say that at that time, the time the decision was made, Deputy City Attorney Mary Shannon was acting in an HR administrator role. So I don't think that she would also have to be sequestered for this time period.
I do think that is the role she played based on the, normally, of course, in these cases, we don't have both of those persons present.
Certainly.
We have either the department, most likely we have in the case of DPW and the health, most likely we have the highest ranking personnel officer. And then in smaller departments, we might have the department head.
Certainly.
Attorney Hitchcock Cross, do you object to having Ms. Shannon here?
Yes, sir.
All right, I'm going to ask her to leave. And she knows she's the second witness. She probably has a good idea of the length of testimony for this manager from the police department, manager. So she'll know how much time to allocate before she has to come down here again. Sorry about that.
President Bach,
Yes.
if I may, there is a rather extensive witness list. I don't know, just to keep the rule consistent in the hybrid format, if the commission doesn't want any witnesses other than the principals to be present, then perhaps there's a way to ask whoever's managing the Teams meeting to scroll through the list of participants and check it.
She can take Ms. Moore, you can, if somebody accidentally hears the first couple minutes of the testimony of this police department person, that's too bad. What we'll do is I'll ask you to go through the witnesses for the department, because the department goes first. And one, get their contact number, and two, ask them to disconnect at this time. That's all I can do.
Okay, President Bach.
People are not in the room.
Okay, just so that you understand that I do not have anyone's contact information and they have already left the meeting. I'm going to remove Philip Islow right now, and he did provide in the chat his contact information, but I do not have anyone else's and they've already left the meeting. And that would be then Attorney Ben Cross that would need to provide that contact information for me. These are his witnesses.
Yes, it does not, our witness list that we receive in advance does not differentiate between who was called by the department and who was suggested by the department and who was suggested by the appellant.
Right.
So all I can do is advise the department as to its witnesses. If the department head testifies, then that's fine. He has a right to be here as the affected party. Ms. Shannon, any city attorney, is their personnel officer. She knows what's happening. and this police department person is up first, so he doesn't have to be. So we can get under, and then I hope, I don't know how many more of those people are your people.
That's it.
Okay, well then it's not an issue for the, for the city, I should say for the department.
Right.
Because we've just about covered it. Well,
Great, thank you, and I apologize for the inconvenience here. There are objections to simply this. This document here is not precedential in any way for several reasons. Number one, it is not between the parties here. Number two, it is between a hearing examiner, Joseph Surge, who has no, this is not a appeals court decision. It is not a Supreme Court decision. This is no effect of law. This is merely what this person thinks. And the most important reason why this should not be considered is the prejudicial value of this is clear because as it states in here, the individual, and although they've deleted the name, and I guess we can leave it out on the public hearing, has been convicted of felonies. And that is categorically different than my client. And the policy that applies there is categorically different, as this CGIS policy handbook that you've read states, that when there's a felony, it's automatic barment from the policy. And if you're misdemeanors like my client has, then it's a totally different situation. So that is, here is my fear. And I know that you have already had a chance, you've been exposed to this document.
that's correct.
But to the extent here, I think it's as important that I make this point clearly, that please do not be prejudiced by this document, because A, it's not binding, and B, it doesn't have anything to do, I mean, which is why it's not binding, with this gentleman here, and that's what we're here for today.
We are aware that administrative decisions are not binding on the commission. However, it does involve the city police department. And I'm aware of the distinction between felonies versus misdemeanors in terms of the regulations that are being cited. But having said that, it also makes it clear that it applies to civilians, not just to uniform type people. And in that sense, the commissioners should consider it as background. And for that reason, after hearing your objection, I'm going to still allow it to be admitted. This document, so far, we've had D10 was the last exhibit. So this will be D11. And the commissioners who've been around on this commission for a long time, even the most junior person on the commission has been here for a number of years. They understand that the administrative decisions which have been entered into the record on both sides in the past, that they're merely background information and do not constitute a precedent in terms of this case. Having said that, I said we're going to go through the exhibits. Right now, that takes care of the unstipulated exhibits. I'll rule on the D1 1A business when we get our first witness at the conclusion of his or during his testimony. But we also have, it wasn't just the department, also the appellant had exhibits which were not stipulated too. Exhibit A1 is a one-page exhibit, which, and Ms. Moore can correct me if I misstate this, but our staff has entitled this Young Timeline. That's how it's described in the summary of the exhibits. The document is undated and the author's name or initials were not shown. Let me make sure.
Excuse me for interrupting, but we will withdraw that document.
Okay, well then that takes care of A1, withdrawn. Just give me a moment, please. Exhibit A2 are 6 pages of emails between Ms. Headley, the Assistant City Attorney, and Mr. Young, the appellant. Let me get that out. And in describing it that way, I would observe that the final item, or first item on page 1 of this proposed exhibit is an email from Attorney Headley to Deputy City Attorney Mary Shanning regarding the concern that was going on in the other emails between Ms. Headley and Mr. Young. It does not appears to be a series of such communications, and they also, other people are cited in these emails who I believe are legal assistants in the department, and their concerns as to whether they be opening and affecting the quality of either the program or of the records. I'm going to start this item by asking, what is the purpose of this exhibit, Attorney Hitchcock Cross?
Thank you for that. So we had put Ms. Headley on our witness list, but the commission, who I just want to note for the record, is advised by a subordinate of the city attorney here. And this is when I'm speaking of the commission, I'm talking about the executive staff decided not to put Ms. Headley on the exhibit list. They informed us that we would not be able to talk to you direct any communications to the commissioners directly about this issue, and that the only opportunity that we would have to address this issue would be here now. I to that at that time. I thought that was prejudicial. I thought that this issue should be decided well and in front of advance of now, because it's effectively putting you in a position of having to decide essentially whether or not we go forward today. And many people would like to go forward today, including my client. So it's that decision to not allow you to address this matter until now in the public by the executive staff, I think is prejudicial to my client as well. The issue here, and this happens from time to time, and this is what we raised, is that Ms. Headley is a witness to some of the conduct that led up to the termination of my client. It is therefore improper for her to also stand in front of you and act as an advocate, because it will be difficult, and this is what the law is, for a decision maker to distinguish between her role as a fact witness. Just for example, she highlights the document, the exhibit that we look at, which again is not evidence, it's argument, and her arguments that she stands up and makes here today. So our offer of proof ultimately, and the reason why Ms. Headley should be a witness in this case, or is a witness in this case, we should have the right to call her as a witness in this case. And frankly, again, we object to the executive staff preventing that issue on her behalf. I guess I also want to just take this opportunity to point out that there was communication between Ms. Headley ex parte and the executive staff.
I'm going to object that this testimony, Mr. Hitchcock Cross.
Okay.
Mr. Hitchcock Cross is going on a different topic.
I can only have one person speak at a time.
Thank you, sir. That's my understanding. If you're going to interrupt me, that's fine, but I was talking there.
Mr. Hitchcock Cross, please direct all of your comments to the commission. I'll ask both attorneys to do that. We need to keep an orderly meeting. This is being transcribed by a court reporter.
Okay, thank you. So again, the issue was that there were communications between Catherine Headley and Miss Moore that were not divulged at the time, and we had to go through extensive communication with them before they actually divulged what had happened, which was just in that instance there, this was a communication about the scheduling of the hearing for today, which was postponed from when it was originally intended to occur, which was some weeks back. Again, the problem there is Miss Headley's role as both the advocate, the communicator on behalf of the city attorney, and a witness here. The witness, again, we have several witnesses who are going to talk, including Robin Pedersen, about their communications with Mary Shanny, who apparently now we've heard on from the witness, Miss Headley over here for the first time, was acting as an HR capacity at this point.
Well, that's evident from the paperwork.
Well, and from the testimony that we heard, right?
But I didn't hear the testimony until this morning, but I saw the paperwork over the last couple of weeks. It's clear that she was the personnel officer.
Right. So to the extent that this witness is giving information to the personnel officer about my client, we're entitled to examine her as to why she was doing that and what was the purpose of this October 10th communication sent to Mary Shanning by Ms. Headley by snipping tool about my client, and why there were other communications at that time for similar reasons.
Well, this is the reason I'm concerned about this document is it's a little far afield from the issue. If you look at the actual separation notice, the person was, Mr. Young was separated because he didn't have the clearance under that CJIS policy. And it isn't these other issues. If that is, first of all, the obvious question is, does he have the clearance? Assuming he does not, then the argument is it relevant to have that clearance for that job? That's the issue. This is so minor, in my opinion, just looking at the material. I'm surprised it's submitted, but
Let me respond to that if I can, because I think it raises a two-part issue. And I think the first issue is that it seems to me that there's an acceptance that the termination letter on its face is accurate and truthful. And
well, that's a question that you can raise
well, thank you.
in this hearing.
Right. So we intend to do that, and I think that's my job here, and that I'd be derelict in my duty if I wasn't doing. So to the extent that I understood what you were saying was, if we're assuming that what is in the termination letter is true, then this is far afield. And so where we are, for example, and my job is here today is to suggest to you all that what's in the separation letter is not accurate. And by the way, if we are at the point right now, sitting here today, at this moment here, commissioners, that we do agree that what's in the separation letter is accurate, then let's not continue with this hearing any further, because there would be no purpose in doing so, because A, the decision would be made, and B, then this would be a waste of time. So let's not waste any more city resources if that's the case.
Well, the argument that Mr. Young himself made in his appeal, which he attached to his, where he appealed, there's an attachment, he filled it in. He said, well, I've been doing this job for a couple of years, and it hasn't affected my ability to do the job. I assume that that's what this hearing would be about, that he probably doesn't have clearance the question is whether or not that's relevant to the performance of the job. And that's why we're having the hearing. And if there are some minor kerfuffles about some document being opened by legal assistance, and they're bringing it to the attention of Ms. Headley in her role as assistant city attorney, and then she's telling Ms. Shanning that, hey, we have a concern that has not been sorted out. That doesn't go to this case, in my opinion.
Great, and let me just give you another theory here, just to help you out, because I understand that that's one theory, okay? And but there may be others, and that may be what the point of cross-examination is. But there may be one theory where my client signed a background review in 2022. There may be a theory that instead of sending the Milwaukee Police Department, instead of sending that information to, say, the city attorney at that time, that they send it to Robin Peterson. It may also be the case that we find out here in testimony that Robin Peterson and Celia Jackson terminated my client back in 2022 before the actual person who was authorized to do it without authorization. When Mr. Tierman Spencer found out about the illegal termination of my client, he reversed that action back in 2022.
And some of those documents are in the record.
Thank you. And it may also then be the case that going back into 2024, that there may have been some issues between city attorneys and my client.
Well, that's what we would get into in the hearing. But
So then that's why we may want to have this document may assist us in getting into it. That's where we are. And I think we've covered that, so I don't have any more argument to make on.
commissioners, do any of you, would you prefer to have this in the record or no?
In which document are we?
We're talking about AU2.
I'm not sure that I think it's that important, but I don't have any objection to keeping it in.
May I be heard on the
Yes.
argument of me being a witness here?
Well, that's a separate issue.
Okay.
And the city attorney, under the civil service law, he's a department head. He, like any other department head, if the appellant is represented by counsel as opposed to representing him or herself, or as opposed to having a union rep, whenever the appellant has a counsel, the department head's allowed to have a counsel. And you are it. And I personally, my inclination is to not have you as a witness in this case, because these other, and some of them have been one of them has been referenced. He's a deputy city attorney. The other people involved here, the information can be brought out through them, through other persons, not by you. My opinion is that your role is going to be as the counsel for the department head, who happens to be the city attorney in this case. As to AU2, I don't think it goes to the merits of the case, but I don't want to spend any more time on this thing. I'm going to allow it to be, and this is a phrase that is used in arbitration it'll be entered for what it's worth. Now, as I indicated, the record between the parties has 25 stipulated. So this would be A26. The next one is one that I'm interested in. It's AU3 is the job description. I think it's 5 pages. It's a job description dated January 14th, 2022 and the title at this time back then was IT Support Specialist Senior. But I believe we have in the record the fact that this is the same position and the title is reclassified to business operations. manager. So this is the job description for the previous incumbent, a man named Jonathan Stepner. But and I said IT support specialist senior. This was not. I don't have to ask Attorney Hitchcock Cross as to why they're asking that it be entered. We're talking about what's the work, the nature of the work of this position, and whether or not he needs a clearance under that federal policy. I'm going to go directly to counsel for the department, Attorney Headley. What is the objection to the early job description?
Thank you, President Bach. The objection here is that this is an unsigned job description. If you look at the page 5 of AU3, it is unsigned. At the time that we were reviewing this, I did not have the ability to check and verify that it was an accurate and true job description. And given the fact that it was unsigned, that lends itself to the fact that it is specious at best. And also A18, which has already been stipulated to and in the record, is the job description at issue during the time period where Mr. Young was let go from employment.
Right. And that's part of the record.
Correct.
But part of the argument in this case, and remember, we got to, what the case is about is this position, whether it was held by Steckner or Young, and whether it was the senior specialist or whether it's a business specialist title. In any case, question is whether the clearance is required based on these job duties. And I think it's helpful to the commissioners to have both of these job descriptions in the record, because we know that there was some kind of termination action back in 22, and then there was the current, which is a non-appealable, but it was changed, and we're probably going to hear about that. But it was, we then have the new job description because it was reclassified upwards slightly. With that, that would be, because the emails were admitted as 26, the court reporter should mark what AU3 had been, that should become A27. And then finally, we have what's been marked AU4. It's 2 pages, and staff has described it as questions answered by unknown person. I'm going to describe it, besides being 2 pages, it's a typed document about the position in question, and Mr. Young, pardon me, only 1 page is typed. The second page is handwritten. However, I did not see a date or an author indicated, and so my question to Attorney Hitchcock Cross is, who could identify among their witnesses, including the appellant, who could identify where this 2 sheets came from, and who's the author of these, on the one hand, the notes on the type page, but then there's also some handwritten notes attached on just a sheet of paper, a lying sheet of paper.
And to ask that, or to answer that, the A6, which has already been admitted, is going to be helpful. And so back in 2022, there was an OIG investigation into the termination, the undone termination of my client by Mr. Peterson and Ms. Jackson. The OIG asked Ms. Jackson a series of questions that's embodied in A6. Those are the responses here. The document that we're talking about, for the record again, AU4 is the notes taken by Ms. Crow to generate AU6. So the short answer to your question is Ms. Crow, the witness, is going to be able to identify this document.
All right, well, then you've just prepared the answer on this one. We will hold this document until Ms. Crow testifies. And Ms. Crow's notes from 2022.
You do have an A6. A6 was not denoted in the top right-hand corner. It is, every other document was, A6 wasn't, so it might be back of A5.
It's not, goes from A5 to A7.
Oh, okay.
Thank you for.
Okay, I have 8.6 and I note that I had to put in,
And I don't have A4 either.
I had to put in a, my own identifier of A6 on that page. And it is, it is from Sharon Crow to Celia Jackson. And that is part of the record. So we, but whether that was in here or not, this has to do with the job duties related to Mr. Young. And we'll have Ms. Crow identify that if and when she testifies. All right. That's we've done two main parts of exhibits. Now the part I like the least is the next one. And that's where I'm going to ask each of the parties whether they have any new or additional exhibits. And if you have a new or additional exhibit, you can bet that my first question is, why wasn't this submitted ahead of time? Like I explained, and I should have explained at the very beginning, at each step we go first. And so my question to Attorney Headley is, do you have any new or additional exhibits?
No.
My question to Attorney Hitchcock Cross is, do you have any new or additional exhibits?
No, thank you.
Thank goodness. Thank you.